Well, welcome everybody. Today we're going to focus a little bit on patentability or patentability searches. A lot of our clients ask us, do you do searches to see if my idea is patentable? How do you do it? Some people just want to know how to go about doing it because they want to do a little bit of that work on their own. So before we start, let's define what a patentability search is. Basically, what you're doing is you're searching any public database for any information that would disclose your invention or that has parts of your invention disclosed in it. And it could be any public source. So it could be issued patents in the US, it could be issued patents throughout the world. It could be published pending patent applications throughout the world in the US. It could be newspaper articles. It could be anything as simple as technical journals that are existing in the world for different universities. So anything that can be publicly found and searched, whether through a library or through an electronic system, is fair game for patentability search, because that's kind of what the Patent Office does. They search for any public document to see if something is patentable, and based on their analysis, they'll let you know. I also want to make a distinction between a patentability search and an infringement search, or freedom to operate search. So what an infringement search is, or a freedom to operate search is trying to determine if there's any issued active patents that you could potentially be infringing by making a product that you have come up with or thought of. So there is a difference between patentability search, because it looks to see if you can get a patent, and a infringement search or freedom to operate search, which looks to see if there's any issued patents. And the main difference is the database you're searching. In the infringement scenario or the freedom to operate scenario, you're looking at just patent databases, so issued patent databases. So the US Patent and Trademark Office, which I'll show you how to find that and how to search that. So in an infringement search or a freedom to operate search, what you're doing is you're looking at issued patents, and then you're going to analyze the claims of those issued patents to see if they cover the product or the service that you're going to provide. In the patentability search, you're looking for anything that discusses your idea, and it could potentially have information in it that can be an issue or a concern in terms of getting a patent claim allowed. So that's the difference. And so today we're going to focus just on the patentability search. If you have questions as I'm going along, feel free to put them in the chat. I can, address them in real time, or we'll address them at the end, whichever seems to be most easy. I'll just take it that way and move on from there. A lot of people also ask me, do you do patentability searches? And the answer is yes, we can do them. And then they ask, well, should you do them? So the other question that is always out there, and I'd like to address that a little bit and give you some thoughts and some pros and cons on doing a patentability search. So let me start off at the very highest level, which is the fees that you pay to the Patent Office for filing a patent application, not what you pay the patent attorney, but the fees that you pay for the Patent Office are broken up into three parts. One part is called the filing fee. One part is called the examination fee. And the third part is called the search fee. That's the fee that you're paying for the Patent Office to do the search, a similar search that you would do, but the Patent Office has its own databases, and it has access to its own set of information, which could have been acquired through examining other applications, or it could have been acquired through a knowledge shared among patent examiners. In the context of the pros and cons, remember that one of the things you're doing is you're paying the Patent Office to do a search. So you may not want to do the search on your own. You may want to just pay the Patent Office to do the search. So then after you look at that and you say, okay, I'm willing to do the search myself, even though I'm paying the Patent Office to do it, the next question comes down to cost. Like I said, there are many different databases that you can search for a patentability search. For example, you could search the US Patent Office database. You could search Google patents and find anything. You can search Google in general for any newspaper article or anything. So the more databases you search, the more things you're unlikely to uncover. So when you do searching, one of your costs is the number of databases that you're going to search. Now, some databases are private and you have to pay for those services. Other databases are public and you don't have to pay for them. But the bottom line is the more databases you search, the higher the cost. So this is going into the pros and cons of doing searches. So as you drive the number of databases up, you get more results, which the cost goes up, both in terms of the number of databases you search and in terms of what you're going to have to pay an attorney to look at and examine the search results. So at the end of the day, the search results are of no value unless you actually look through them. Now, you could look through them yourself if you have a comfort level of looking at patents or public documents and you understand the legal system well enough to know how these things will impact claim language and patentability. So as you do more searches in more databases, the cost goes up, both in terms of the number of databases you do and in terms of what you pay the attorney to look at the search results. The average cost of doing searches can be anywhere from about $500 for a professional searcher to search for you, all the way up to, $6,000, again, depending on how many databases you have them search and how precise or how wide scope your search can be. And we'll get to, the precision of your search in a minute when we talk about how to formulate your search strategy. So one pro is you do the search on your own. And the con to that is you're already paying the patent office to do it. Another pro is if you don't do the search, you save the money. The con is if you do the search, you pay the money. Now, what is the advantage of doing the search? Well, if you do the search, you have more data points. So when you go to write your patent, you can be a little more selective and precise in the language and the way you write your claims based on your search results. However, again, there's a cost associated with that. So you have to kind of do the balancing act. And the last thing that's important to note is what you uncover and the information you uncover, you have to keep track of for the purposes of citing it once you file your patent application. So if you do the search and you decide that your idea is patentable, there's nothing out there that discloses it, then you need to keep track of what you have so that you can cite it to the patent office because it's knowledge that you have. And one of the requirements is that you disclose to the patent office in what they call an information disclosure statement, the references and the things you found and looked at that you thought were relevant. The last thing I'll say is when it comes to making a decision to do the patentability search is how familiar are you with the space or the industry? I'm neither a fan of doing patent searches or patentability searches, nor am I against doing patentability searches. I think it's a fact-driven decision. By that, I mean, if you're going into an area of technology that you're totally unfamiliar with, and you really don't understand the field, and you're going to hire some people to do the work for you, it might be better for you to do the patentability search to see what's out there. On the other hand, if you're someone who's worked in that technology field for 10, 5, 15, 20 years, and you're pretty familiar with what's in the field, then perhaps maybe a patentability search is not worth the money because your familiarity probably is just as good as any patentability search that's going to come back. So again, it's one of those things where you have to do some fact finding on your own. Also keep in mind that when you do searches, especially when it comes to patent databases, a lot of patent applications don't become public until 18 months goes by from their priority or filing date. So it's quite possible that something was filed 6 months ago and you'll search and you won't uncover it because it's not made public. However, after 18 months, it will become public and it can be used as a reference against you going all the way back to its original filing date, not the date it became public. All right, so that kind of in a nutshell is the patentability search, what it entails, what it includes, and what you need to do. So bottom line, keep in mind that paying for a patentability search is a decision you have to make that's both financial and fact-based, and then you have to have the information ready for the patentability search. Now, you need to have this information ready if you're going to do it on your own too. So now we're going to focus a little bit on doing the patentability search on your own. How do you go about formulating the search? How do you go about formulating the language or the words or the things you're going to use to do the search? So as you know, when you go to do a Google search or something like that, you put in a couple of keywords and you search and you find some things. That is sort of what you need to do here, but in the context of having written some sentences or some thoughts as to what it is that you are going to be searching. So I'm going to share my screen of a published patent application. Let me put it up here and you guys can take a look at it with me and I can tell you some thoughts. If you look at the document that's on the screen, and I'm going to make it a little bit bigger in the hopes that it is easier to read for everyone. This document is a published patent application. So someone wrote this patent and published it. It has basically, you know, the names of the inventor, the title of the invention, and then the abstract. So I highlighted the words automatically maps the paths. So this thing is about a network on chip design tool, and it talks about automatically mapping the paths listed in the timing report. So these are the kinds of words that you would want to search. So for example, you might want to search the word network on chip. You might want to search design tool. You might want to include automatic mapping of paths, and then, you know, listing a timing report and looking through the application and some of the figures. So, you know, they've got, you know, configure a network on chip, export, and RTL. So these might be terms that you would want to put in and search for. Again, the more terms you put in, the more precise your search will be. So in this example, they've got these figures and you can look through this, and this would be something you would have created on your own about your idea. So you may have created some figures, but more importantly, you would probably have written, you know, some paragraphs about your invention and your idea. That way you can go in and write it. So here is the application itself. Looking at the background, this basically is the background of the invention. So these are kinds of things that you might want to look at. So this one talks about a master, a slave. It talks about intellectual property core or blocks, IP is what it's called. But these are referencing things that are in a circuit or a computer, not intellectual property as in patents, trademarks, and copyrights. Then you can, based on the language that's here, formulate your own search. Now, if you look at this, there are various different ideas that are being presented here. Pipelining is being presented. Area is being presented, and then it goes into a summary. Again, this summary looks a lot like the abstract. And so if you look at this, you can kind of see what it is that they're trying to do in this. And that would be something that you would have had in advance of writing this patent application. And this would be the information that you would formulate to form a search. With that being said, I think the most important thing here is to have some good paragraph explanations that talk specifically about the problem that you're solving and using those things as key search terms. So for example, here you see in the background, it says it is desirable to limit or at least observe the area of a knock in order for the designer to control the trade-off between size, speed, and architecture. So this is the problem that they're trying to solve. And then their solution is what's in this application. So, you know, you're looking here and saying, okay, with regards to area, timing, and performance, you have these various different ideas that you're searching. So without getting too lost into the weeds, I want to say that if you're going to do a search, you need to have specific terminology that is important to your invention and use that terminology to find other things. So for example, in this scenario, I think network on chip design tool is an important terminology, looking at the idea of area, speed, performance. Those are language that you would want to do or search for. Again, this application has already been written, so the patentability search would be irrelevant at this point because it's been written and filed, and it was back in 2012. So it's been around for a while. So if I had this information in front of me before I filed the patent application, I would then be looking at certain things. Like if you again look here, it says network on chip design tool and what it's doing. And they have all these different figures that explain the process. And then they also talk a little bit about, as we go through here, the claims. So in the claims are very specific language, which if you can write the claim before you do your search, it would be great, because you would then take the exact language that's in the claims and begin to search around these different things. So we're looking at displaying the area, we're looking at a network on chip, we're looking at a graphical user interface, and we're looking at these two steps. That is probably something that you're going to do a search on. So now you've prepared what you're going to use as your search terminology or your search parameters, and you can do one of two things at this point. You can hire a professional searcher and give that information to them, and they go off and do the search and bring the information back to you. Or you can go do the search on your own. So now let's assume that you're going to go do the search on your own. The question then becomes, what is it that I can use as a database, or where do I go to make the search happen? One of the things that I want to make clear here is that there are various databases. Any database is a database that you can use to collect information. I'm going to focus on 3 databases. The first one being the US Patent and Trademark Office database. The second one being Google, using Google Patents as a way to search, or Google in general, to search for different articles or publications. And the third one being various third-party databases. There are various databases that are private, that are subscription-based, that you can sign up for, and some of them are month to month, so you can sign up for 1 month, do all your searching, and then cancel your subscription. And from there you can go. There is numerous of those things. So that being said, let me begin by looking at a specific database, which is the US Patent and Trademark Office database. I'm going to again share my screen. This time it's going to be much harder to read the information on there because it's such fine print. However, it is the Patent Office database. So how did I get to this page? So let's start from the beginning. So if I go to uspto.gov, I come to this page. On this page, there's a heading called Patents, and then underneath this heading, there's one thing called Search for Patents. So if I click on that, it'll bring me to this page. So this page has various different databases that, I can search. They give you a 7-step strategy for how to proceed with patent searching. They have details on how the system works. And then here it says Patent Public Search. So you can go into here, you can do searches by all different kinds of parameters, but you can search published sequences. By the way, that's for sequences in terms of formula and things like that. You can search international patent offices by clicking here. So I'm going to click Patent Public Search. When I click this, one of the first things that comes up on the screen is the Patent Public Search. And again, I was here, I clicked on it, it took me to here. And then it says, welcome to Patent Public Search. I click Start Search, and it brings me to this screen. Oh, it's saying it's already open. So I apologize. Let me get rid of that. So it brings me to this screen. I put in this word here, knock, just to do a quick search and show you, but you can put anything on here. So if you recall, we said, for example, network on chip design tool. So I can have these words connected by or I can have them connected by and, or all this. So I'm going to have them connected by and I'm going to tell it to search for singular and plural. I can tell it to search for British equivalents, and there's various other options. But once I click the search, it'll go off and do a search for me. And here's all the different things it found. Now, one thing that's important to note is that this document ID number If it starts with something that looks like a year, like 2022, these are published applications. On the other hand, if it starts with a number that's in the millions, like 11,327,607, that's an issued patent. So if I click on this, that's this document right here. It gives me basically the name of the inventors. It gives me the name of the company. If I click on the next one, it gives me the document number. Again, this is a published application. So it published on May 5th. So it just recently published. The company name is Apple, which we're all familiar with. And again, look at when this application was filed. 2020, February 07. So as you can see, a fair amount of time has gone by between when it was filed and when it became published. And remember, this document can be used as a reference as of this date, not as of this date when it became public. And then, of course, if you scroll through the document, this idea of network on chip design tool should appear, and it's highlighted. And as we scroll through it, you'll see. So it's got the word tools highlighted. And as you read through this, you kind of begin to notice, wait a minute, this is not really related to what I'm looking for, because it used the word tools and found it. So we can further refine our search by saying these words have to be near each other. And near is typically within 10 words, so, or within the same sentence. So once we tell it to do a search, it found no results with that. So let's take out the word design tool. And let's just look for network on chip near tool. And again, it found nothing. That's because this word network on chip may be a word that is not written out. It may need to be replaced with the word knock. And again, if you're familiar with the area of technology, you understand how these terms are used. And as a result, you're better off when you go to create your search. And I'm guessing that I'm not misspelling anything. The design, okay, let's search for this to see what comes back. All right, it found two things. So let's see if now the word knock and design and tool appear near each other. And here it is right here. So for example, it says knock design tool. And so I would read through this and I would say, okay, does this seem to be teaching the invention of looking at performance, speed, and size in terms of various paths? Remember the published application I showed you? That's the one that we're going to write a patent on and file, to see if this is related to it. And as you read through this, you can see that there's a detailed description. Maybe one place you can start is by reading the abstract. It says comprising a knock fabric, plurality of routes. Does it talk about, this is more focused on a built-in self-test. So this may not be relevant to what I'm doing or what I'm going to be filing a patent application on. So I might allow this to go. Now, jumping on to a different search tool, and let me show you Google. So here's Google Patents. And if you search here, again, it's the same thing. You can put knock design tool, and it'll bring you back a whole bunch of list of things. You can even, if you don't want to search just in the patent database, you can actually go to Google itself and search for knock design tool. And now you should be getting all different kinds of websites and articles and publications that you can look at that relate to your invention. And the last, of course, is the third-party databases. There's a bunch of different third-party databases. By the way, I misspelled design. So here's, for example, if you look at desktop application for network on chip design, then here's, someone who's selling a product, and you can see that their information is listed here. This may not be the best source to look at because you're probably looking for something that is a publication or an article that you can look at. So all that being said, let me open the door to the following. So let me do a quick recap. Patentability searches are looking at different things that are made public. Not the same thing as an infringement or a freedom to operate search. There's pros and cons to doing a search, and the more familiar you are with the field, my personal opinion is there's the less the need to create a search or do a search. On the other hand, if you do a search and you're familiar with the field, you can write a patent application that's more precise and presents a better story because you're anticipating what the patent office might use as a reference against you. And finally, there's various different databases that you can use. You can do the search yourself, or you can go to a third party and hire them to do the search. And that in a nutshell kind of sums up patentability searches. So now the questions, if there are any, we can take them. Nicole is here with us. She can help field questions. And Brian and Daryl, you're both here. Welcome. Thank you for joining. If you have any specific questions, feel free to unmute or throw your questions into the chat, and I will do my best to answer them. We have all of 3 minutes to answer questions. Nicole, are there any questions that came in through the live feed?
Yep, I just popped some in the chat for us.
Okay.
Jubin, have you had any experience with like a claim IP or a patent optimizer or those kinds of analytics programs for doing searching?
There are tools that optimize your patent application. Are you suggesting those tools could be used to do a search, or are you asking about something different?
Yeah, a claim IP. I did a trial run on that and found that to be pretty effective.
Okay.
And Patent Optimizer has a way of kind of taking claim language. Both of them can kind of take claim language that you think might be where you want to be at and run those off in a search and kind of do some analytics on it and so forth. They can be quite costly, and it's been a while since I've used them, but an interesting experience in using them.
Yeah, those are private tools that, again, you pay for the service. And the idea of having your claim language, I think, which is one of the things we talked about, is, you know, in having your search terminology could be the claim language that you want to use. And then you can run that through a search or give it to a searcher, and they can come back with some tools and analytics.
Yeah, yeah.
There's one question that says, are there particular sectors of innovation where a search may or may not be most beneficial? I think that kind of depends on the area of art and how crowded it is. So the more that has been done in that area of art, the better it is to do a search. As opposed to an area of art that's very new. So for example, right now there's a lot of filings happening around artificial intelligence, training of these models, AI models, and these kinds of things. So there's not going to be a lot of data out there on it other than published articles in journals and things like that. So perhaps maybe that's a sector where it's not as valuable to do a search, versus if you're going to do a new semiconductor chip design, you know, and doping process for making a semiconductor chip, you might want to do some searching because that's a very crowded area. That art has been around since the 60s. There's been a lot of development. So I would say that the more you have in terms of the age of the technology, the better it is to do a search, because it'll help you uncover things that may not be known to you. On the other hand, if you're very familiar with the area and the field, you may know exactly what's out there, or very precisely with a very good idea of what's out there. Another question came in. Should I only be concerned with a search if I'm filing a non-provisional application? That's a very good question. So the difference between a non-provisional, and I'm assuming the other thing that they're thinking about, is a provisional application. Provisional applications are never examined, and they sit for a year and then expire. So I would say that if you're going to file a provisional, you're probably doing it to do cost savings, as opposed to filing a non-provisional. So it's probably not worth doing a full search on a idea that you're filing for provisional, because again, it's not going to be examined. When you get ready to file the non-provisional, you might want to think about doing your search at that time. So I don't think you should do a search when you're doing a provisional. I think when you're doing non-provisional, that's when you really need to think about the options of doing a search and a patentability search. Okay, we're right at our time. I appreciate all the questions. Thank you for joining us. I would really welcome you to reach out to us. We have a channel on YouTube that provides a lot of this information. It's called The Patent Guru. If there are any questions or follow-up things that need to be done, please reach out to us. Thank you.